Okay, so I want to welcome you to the last in our series of lectures on introducing issues of diversity and social justice into the first-year curriculum with Professor Bargill. Because this is the last session, first of all, I want to thank you for attending this, and those of you who have attended prior ones, thank you. I also want to thank the Dean's Office for the support it's given to the program, and particularly to Sharissa Ellis in the Dean's Office, who's done a spectacular job of supporting the program and being nimble when there were sudden changes that we had to implement. Today, Professor Bargill is going to talk about contextualizing contracts. This completes the series of lectures on each of the first-year required courses, and I hope you find it interesting.
So thank you very much, Mark, for inviting me to be part of this program. I'm delighted to be here and to talk to you about contracts. I'm actually baffled how contracts is the last rather than the first topic in the series, but I take what I can. All right, so I'm going to discuss this broad topic of diversity or contextualization in contract law, and I'm going to try to touch upon at least 4 dimensions of diversity and context. And of course, each one of these deserves at least 3 days of its own just to kind of cover everything. And I'm going to be just touching very briefly on some of the things that you probably encountered or may have encountered in your 1L contracts classes, and some of the things that I kind of view as most important and fundamental in contract law, or in contracts more generally. Okay, so I want to start with the issue of gender. And here I'm going to remind you of a case that I imagine many of you have seen in your 1L contract classes, and at least some of you, my students, have seen it. Oh, I did have to turn on. Oh, I need to actually turn it on? All right. So I'm going to talk about gender. Okay, that was kind of topic number 1 in terms of our dimensions of context and diversity. And I want to start with this case of Parker versus 20th Century Fox. Just very briefly on the facts, as you know, this is the case of a contract between Shirley MacLaine Parker versus the studio versus Fox. And it starts with a contract where the studio has a contract in which it is supposed to have MacLaine star in the movie Bloomer Girl. Okay? Now, it turns out that the studio decides not to produce Bloomer Girl for kind of a host of reasons, and this apparently happens all the time in the movie industry. But they want to make sure, okay, and this is their language, you want to make sure that MacLaine is not harmed by their breach, and so they offer her instead also a lead role in another movie, but this other movie is called Big Country, Big Man. Okay, so this is a Western. And MacLaine declines this offer and sues the studio. Now, the doctrinal issue in this case has to do with the mitigation doctrine. As you know, in contract law, even the breach victim has certain duties. And specifically, there is a duty on the breach victim to mitigate harm, to take reasonable actions in order to mitigate the harm caused. And in this particular case, because this is an employment contract, the duty of mitigation is implemented through this different or inferior test. And so basically, the test says, okay, that an employee, okay, now an employee that was fired, an employee that does not get to play in or to star in this movie, Bloomer Girl, this employee has to take any other job that is offered as long as this other job is not different or inferior. Okay, and so the question in this case turns out to be, okay, whether this alternative job, starring in Big Country, Big Man, is different or inferior. Because if it's different or inferior, then MacLaine doesn't have to take the job, and she can get full compensation from the studio. Okay? But if it is not different or inferior, okay, if this is a reasonable alternative, then she has to take it. Okay? And if she doesn't, she's not entitled to damages from the studio. Okay? So this is the case. Now, the court, in implementing this test, okay, or at least the majority in the court, tries to identify differences between Bloomer Girl and Big Country, Big Man. Okay, and so the court, the majority, in fact, concludes and rules that this was a different or inferior job option, and therefore McLean is entitled to full remedies. But the interesting point here is how the court reaches this conclusion. So the court reaches this conclusion by going through these differences, listing a set of differences, okay, between the two movies. And here are the differences that the court emphasizes. The first is that while Bloomer Girl was supposed to be filmed in LA, Big Country, Big Man is supposed to be filmed in Australia. So this is a difference. I'm not sure which one is better, but it's definitely different. Okay, the other is that we had Bloomer Girl is a musical and dance performance, musical dance role in this movie, as compared to a dramatic role, okay, in Big Country, Big Man. That's a difference. Okay? And finally, the court notes that there is some less influence over screenplay and director in the kind of Big Country, Big Man contract as compared to the Bloomer Girl contract. So Shirley MacLaine has a little bit less kind of influence. Now, these are differences, indeed differences between the two movies. Okay? But as the dissent suggests, just listing differences doesn't tell us very much. Are these differences important or not important? How big are these differences? Maybe how small are they? And indeed, what really is going on here, or what is perhaps the biggest and most important difference between Bloomer Girl and Big Country, Big Man, at least from the perspective of the breach victim of Shirley MacLaine, has nothing to do with any of these differences that the majority kind of enumerates in its opinion. Okay? Rather, okay, and here I'm kind of quoting from a great article by Mary Jo Frug, okay, and this is her description of the real difference between these two movies. Okay? A female lead role in Western film would presumably have involved little more than standing about in flimsy frock, tearfully begging Big Man to settle down and leave his guns at home. Okay, so that is the alternative that is being offered to Shirley MacLaine. And Frug compares it, okay, to the lead role in Bloomer Girl. Okay, and this is a movie that was supposed to be celebrating Amelia Bloomer, one of the kind of early kind of feminist activists, which was really important to Shirley MacLaine herself, and very politically active in the feminist movement. Okay? And so the idea here is that there is an important difference. Okay? And this important difference has to do directly with this importance of feminist political activism for Shirley MacLaine. And that is the difference between these two movies. And that is the difference that should count. Okay? And this is a difference that the court entirely kind of glosses over, or at least does not recognize in its opinion. Okay? Now, you might kind of say, well, why should we care about this difference as long as the court reached the right conclusion and Shirley MacLaine won the case? But of course, as you know in law school, it doesn't really matter only what the outcome is. The reasoning of the case matters a lot too. Okay? Because if the courts do not explicitly recognize the importance of this political kind of significance, personal significance of the gender issue to the breach victim, then in future cases, when they just enumerate Australia versus Los Angeles, another court might just decide, well, Australia is better, okay, and the lead, and then the breach victim is going to lose. Okay, so this is my kind of example number one. Okay. Another example of gender in contracts has to do also with the question of remedies. But here it has to do with the questions of injunctions, specifically negative injunctions in employment contracts. Okay, so what you want to think here is about a situation where an employee decides to quit, okay, her job, okay, and work for some other employer. You might imagine that this employer is a competitor of the first employer. Okay, and the first employer is trying to prevent this, her employee, who now maybe has learned a lot, okay, on the job, from going and taking all this knowledge to the competing employer. Now, in this context, we know that in some cases, at least in some states and certain jurisdictions, the law would award a negative injunction. And we know that specifically because of 13th Amendment considerations, we cannot force, the court will never force an employee to work for a particular employer, okay, in terms of specific performance or positive injunction. But under certain contexts, the law would recognize and grant a negative injunction, namely saying, well, you don't have to work for A, but we won't let you work for B. You can imagine that in many cases and for certain employees, this alternative is practically the same as a specific performance positive injunction. Because if I can't work for anybody else, and I really need money in order to support my family, then I will de facto be forced to work for the initial, or the employer A. But the question that I want to raise here has to do with the historical origins of this doctrine, of this line of cases that has allowed, at least under certain conditions in certain jurisdictions, has recognized and allowed these negative injunctions against employees. And the reason I'm mentioning it in this context is that historically, these types of negative injunctions were granted, or this doctrine was developed, in the context of female employees who tried to quit and stop working for a male employer and go work for somebody else, usually another male employer. And because the kind of sexist attitudes at the time, okay, and these women employees were considered to be not kind of fully autonomous, but in fact tied in a status kind of way to their male employer in the same way that they were tied at home to their kind of husbands or fathers. Okay, the court didn't feel it was that bad. Okay, it was so harmful to issue negative injunctions against these female employees. Okay, so this is a second example of the role gender played here in the historical evolution of remedies doctrines in contract law, and specifically in this context of negative injunctions in the employment context. I want to move now to kind of the second dimension of kind of context and diversity that I listed before, and that is the context of race. And of course, we were talking about the first-year contracts curriculum. The most important case that is taught and discussed in this context is the case of Williams versus Walker-Thomas. Again, I'm sure that all of you are familiar with the facts of this case. Just briefly, Mrs. Williams was purchasing and signed a series of contracts. These are like rent-to-own type contracts with Walker-Thomas Furniture. And in one of these contracts, there was in the fine print a cross-collateralization clause, namely a clause that says that until you have paid your entire balance on all of the different items that you have purchased, okay, until you have paid everything, okay, there is still, if you miss a payment, we can repossess all of the items that you have paid before on all of the prior contracts. Okay, so this provides much stronger collateral or much stronger support or protection for Walker-Thomas, and of course, the implications for Mrs. Williams if she misses a payment, as indeed she did in this context, are much more dire. And this cross-collateralization clause was discussed, or was analyzed in the Williams case under the doctrine of unconscionability. In fact, this is one of the earlier cases that developed the doctrine of unconscionability and presented the two-pronged test of procedural unconscionability on the one hand and substantive unconscionability on the other hand. And the court here had to decide whether the cross-collateralization clause is unconscionable, whether it should be struck down or not. And now to the issue of race. Now, the first thing to note is Mrs. Williams was black. And it's also important to note that the fact that she was black was not mentioned by the court in its decision in each one of the kind of the trial level and the appellate level. This factor was not mentioned. It's also important to note that in most case books, that factor is not mentioned. And this is, of course, kind of an important omission. And it's also important to understand, and it's not really obvious, to figure out exactly what are the implications of Mrs. Williams's race in the determination or for the determination of unconscionability in such a case. Okay, so one clear implication is the following. Under the doctrine of procedural unconscionability, okay, one of the main questions that the court asks is whether the party, the plaintiff, Mrs. Williams here, had meaningful choice. Whether there was meaningful choice between dealing with Walker-Thomas or buying from somebody else. In this context, race is really important. Because if you're thinking about inner city DC in the 60s, where race-based discrimination, specifically against African American, was rampant, okay, the choices available to somebody like Mrs. Williams were very limited. Okay, and this, at least on its face, should be a very kind of powerful kind of argument in favor of a procedural unconscionability finding under the meaningful choice doctrine. Having said that, the fact that Mrs. Williams, specifically because she was black, had very limited options, had very limited choices, this is also leads us, or should lead us, to question how wise it is, or how helpful it is to Mrs. Williams and to others in her position if we now use unconscionability doctrine to strike down the cross-collateralization clause. We need to ask ourselves, what would be the implications in future cases? What options would now be left to Mrs. Williams and to others in her position moving forward? And here the point that I want to emphasize is that a cross-collateralization clause, because it provides extra protection to the retailer, to Walker Thomas, extra protection against potential default and non-payment by its customers, this cross-collateralization clause allows Walker Thomas to reduce the price that it charges for the different items that it is now selling on this rent-to-own basis. And so if the court now says cross-collateralization clauses are unconscionable, they're not enforceable, you can't use this technique, this means inevitably that the risk now, the cost of doing business to Walker Thomas goes up, and with it, likely the prices charged to Mrs. Williams will go up. And so we really need to ask ourselves, and we need to ask ourselves very carefully, if this is a result that would be good for Mrs. Williams, especially in light of the limited options that she has in terms of other retail options with other kind of terms of credit, and with other potential sellers. A few more examples. This is now taking a step back from kind of contract doctrine per se. Just a few examples of very important evidence of discrimination in contracts, and race-based discrimination in particular. So in focusing on mortgage contracts, and this was, of course, true leading up to the financial crisis, it's still true after the financial crisis, there is convincing evidence suggesting that African Americans and Hispanics borrow from riskier lenders. And there's also evidence that even within, if we're talking about an African American borrower as compared to a white borrower, or Hispanic borrowers compared to a white borrower, going to take a loan from the very same lender, even then, there is evidence suggesting that the African American and Hispanic borrowers are going to get worse terms and other forms of worse treatment as compared to the white borrower. And this is controlling for all the other things that we would imagine are associated with risk, like income and assets and credit scores and so forth. Another kind of very important, I think very powerful example comes from this article by Ian Ayres. In this article, Professor Ayres sent testers, basically actors, to negotiate car sales, contracts for kind of buying cars. And so he sent these different testers. And there were testers of different races and different genders. And he tested them to the same dealerships. He sent them to the same dealerships. And he gave them the same script for the negotiation, to keep everything constant other than kind of race and gender. And then he saw what kind of offers, what kind of prices they received. And again, the differences here are quite striking. So as compared to the white men, if that is our kind of reference point for present purposes, white women paid 40% higher markups for these cars, exactly the same dealerships. Black men paid more than 100% higher markups, and black women paid more than 200% higher markups. This is huge in magnitude, economic significance. The third dimension of diversity that I want to emphasize, or context that I want to emphasize, has to do with class or income. And this goes back to one of the most fundamental features of contract law. We think of contract law as a body of law that empowers individuals to engage in collaborative projects, to enter into deals and transactions and improve their situation. So it's an empowering body of law more than kind of a set of laws that impose mandates, like in tort law or criminal law. So contract law is empowering. But the point here is that not everybody is empowered at the same degree or at the same level. And so the idea here is that if we think, and there's reason to think, that the rich have more options and opportunities to contract as compared to the poor, then this empowering kind of virtue of contract law is not evenly distributed across the kind of the income distribution. And so one thing that comes out of this initial point is that in some context, the poor might not have practical access to this empowering tool that is contract law at all, might have no access to contracting or much less access to contracting at all. A secondary implication is that even if they do have access to contracting, when they enter into a contract, how much they gain from this contract would change. Okay, would depend. It would depend on something like bargaining power, but this bargaining power might be correlated with income and class, and maybe also gender and race. And so what you see here is these circles here, they represent the entire contractual surplus that is created by the transaction, okay, that we enter into, okay, that these two parties enter into, a buyer and a seller. Okay, and this surplus can represent wealth or utility or well-being or whatever you want. And of course, it's really important to think not only whether this surplus is created, but how it is divided between the two parties. Okay, and so if we think that one, under this, on this side here, the buyer gets a big share of the surplus, okay, this type of contract would be very different from another contract here in which the seller gets the bigger share of the surplus. Okay, and so again, if we're thinking about who gets the bigger slice and who gets the smaller slice, all of these elements of kind of income and class and gender and race will play a role. Another element of context and diversity I want to emphasize is the question of psychology and bias. And the point that I want to kind of start this discussion with is the observation, okay, that if we think that everybody is kind of perfectly rational, okay, in their decisions whether to enter contracts, for example, in this particular context. If we think that everybody is perfectly rational, then this pushes away many dimensions, important dimensions of diversity. And the reason why it does this is because there's only one way to be perfectly rational. Okay? And when these standard neoclassical economic models, specifically in the line economics of contract, assumes perfect rationality, they indirectly assume away a lot of diversity, because there's only one way of being perfectly rational. On the other hand, while we recognize the possibility of bias and imperfect rationality and all the implications of psychology, then we see that there is a lot of diversity behind this. Okay? Because while there's only one way to be perfectly rational, there are many, many ways to be imperfectly rational. Now, what are the implications of these biases? Okay, so imagine a contract, say a contract between a bank and a borrower. Let's say it's a credit card contract. Okay. Now, this contract may be a contract in which the seller or the lender gets the lion's share of the surplus, okay, perhaps through a whole host of different fees and interest rates and penalties and so forth. Okay. So this is what the contract actually looks like, and this is how it is divided. The seller gets a big share. The buyer gets a very small share. Okay. But with cognitive biases, if we think that the borrower, doesn't fully understand all the set of different fees and prices and penalties and interest rates, some of them might be completely invisible to the buyer. Some of them might be underestimated by the borrower. Then, in fact, the borrower might think that the contract actually looks something like this. So the perceived contract, and particularly the buyer's perceived share of the surplus created by this contract, can be very different from the actual share that the buyer gets. Now, so far, the assumption was that we have the same surplus. The circle was the same size. Just the division of the surplus was different. But of course, the circles don't have to be the same size. Indeed, in most cases, when we have imperfect rationality, at least on one side of the contract, the circles are not going to be the same size. Okay? So if this is the perceived contract, this is what the buyer thinks that she's getting. In fact, what she might be getting is something like this. Okay, and this is not a kind of a typo. There is no buyer's share here, okay, because the buyer doesn't get anything. Okay, so you can imagine that the way the pricing works in terms of all of the fees and the penalties and all the other kind of tricks and traps, like Elizabeth Warren likes to call them, because of all these, the price, de facto price that the buyer pays is so high that in fact nothing is left for the buyer. Indeed, in many cases, the buyer might be affirmatively harmed by entering into the contract.
not only does the buyer not get anything, the buyer actually loses something. Also, as you see now, the circle is much smaller. And this is designed to illustrate the possibility that when we have imperfect rationality and psychology and bias and misperceptions, at least on one side of the contractual relationship, then we may be entering into contracts, or contract may be entered into, that are really not creating that much surplus. Indeed, we might be entering into contracts that are destroying surplus. Not only even moving money from the weak to the strong, or from the poor to the rich, but in fact, the harm to the weak might be larger than the benefit to the strong or to the rich. And nonetheless, these contracts are entered into because of these mistakes and misperceptions. So kind of winding down, my time is almost up, I want to ask you about to what extent do we think, or what effect does contract law have on differences among different contracting parties, different individuals in our society? Okay? So assume that initially, before we introduce this empowering tool called contract law, assume there was a certain distribution of incomes in society. Okay? So this is the income, and this is how many individuals we have at each income level. Okay? So we have few that are very poor, few that are very rich, perhaps initially, and many in the middle. Okay? So one optimistic view of contract law is that this is a body of law that empowers. It makes everyone better off. And so thanks to contract, the distribution would be moving to the right. Okay? So the poor are a little bit less poor. The rich are more rich. And the middle also moves. Okay? So if we think that many contracts that are signed by individuals that are, enter into them freely and are more or less sophisticated and informed about what they're getting into, okay, then they will enter into contracts only if it's good for them. And so they will be improved. Their situation will be improved by this contract law. On the other hand, we can think about a less optimistic view of contract law. Okay? And this view would suggest that if we start here, okay, we might end up here. Okay? And so if we take this position that some people have more access to this empowering tool called contract law, if we think that the rich have more bargaining power, if we think that the rich are less subject to these cognitive biases, not because they're smarter, but because they can afford maybe sophisticated advisors that will tell them what they should and should not do, how they should or should not contract. Okay? Then in these types of situations, we might see that contract law would have this negative effect of exacerbating differences, enhancing disparities, okay? And kind of leading us to a situation where the rich get richer and the poor get poorer. Now, my own view is that reality is some kind of combination of the optimistic view and the pessimistic view. And we really need to encounter more empirical evidence to suggest which one is dominant in which context, again. But definitely this is a concern. And just to conclude, I want to go back and look at the various legal instruments that we have in order to address the problems that I've kind of identified here briefly. Okay? So we talked about unconscionability doctrine and how it can be used to take into account and address some of the kind of biases and differences and discriminations. Okay? We've also seen how unconscionability, if it's not used wisely, can harm those who are subject to discrimination. Mistake and misrepresentation doctrine within contract law can help deal with some of the problems of imperfect information and imperfect rationality and misperceptions. Good faith can sometimes prevent or make it more difficult for the strong to take advantage of the weak. We've seen how mitigation doctrine, if applied correctly and sensitively, can empower and respect non-monetary values, personal significance, and political values. Also, the penalty doctrine. Okay, this is the doctrine that said you can't insert stipulated damages clauses with damages that are too high for breach of contract. This can also be used sometimes effectively to deal with some of these problems, specifically with misperceptions and bias, to the extent that if the strong wants to insert a high liquidated damages clause in the contract in order to take advantage of the weak or the imperfect rationality of the other side, then the penalty doctrine may prevent the strong from doing so. And so there are doctrines within contract law that can address some of these issues. But it's important for me to emphasize that the tools available within contract law are probably not the most effective tools to deal with the problems that I've identified here. But the fact that contract law tools are not most effective does not mean that the law, broadly perceived, does not have effective tools. And so it is really important to note that even these problems in contracting can be solved by tools outside of contract law, narrowly defined. And so the bodies of law that I want to emphasize here are consumer protection law, under the FTC, the federal level, state level, unfair deceptive acts and practices statutes, sector-specific regulations, like the work that the Consumer Financial Protection Bureau is doing in the consumer finance space. Anti-discrimination laws, of course, have an important role to play. And finally, the tax and transfer system is really important. In particularly, note that if we think that contract law, its empowering feature, it works very well if you are rich, or at least not too poor, then the tax and transfer system will have an extra indirect dividend much stronger than we initially might think. So when you move money, when you redistribute to the poor, not only do you have the obvious direct benefit, but by enabling them to enter and make use and take advantage of contract law's empowering features, you get an extra dividend from the tax and transfer system. So I will end here and look forward to your questions.
Thanks. On the Walker-Thomas case, you suggested that maybe the unconscionability of the collateralization would make people in Mrs. Williams' case perhaps worse off because the prices would go up. Of course, ideally, we would want people in her case to be better off by, more opportunities, different stores to shop at. Is there a place for contract law in that kind of empowerment, or do you see it only in anti-discrimination law and these kinds of laws beyond contract law?
Yeah, thank you. So this is a good question, and I think it ties directly to the point that I was making in the conclusion slides about the power and the limits of contract law or contract law doctrine. So contract law does not have the power to force sellers to enter into contracts with buyers. So that is not a power that is within the scope of contract law narrowly defined. And so I really think that in order to really help Mrs. Williams and others similarly situated, we really need to reach outside of contract law, through anti-discrimination law, through other tax and transfer and welfare systems that will, raise people out of poverty and provide them with opportunities, and of course eliminate all racial bias that would keep these opportunities away from them. But yes, the short answer to your question is yes, contract law doesn't have the tools to open up these opportunities in the way that you described.
Is there a way some of those diversity factors actually influence or help some of the tilts and the cognitive bias, or a way that the cognitive bias can fix some of the existing diversity factors? I'm wondering if there are education methods or things in place you can have in law that could counteract between the different diversity dimensions.
So I'm not sure I fully understand the question. So obviously, we want to use education, on multiple dimensions. So we can use education to perhaps eliminate some kind of misperceptions. Just to give a simple example, if consumers are getting mortgages because they don't understand the true cost of the mortgage, we want to educate them. We think financial education can be helpful and prevent them from entering into contracts that they should not enter into. Now, to the extent that these types of misperceptions are implicated at a different level across maybe different genders or different races, then this type of education, the same type of educational campaign, may also have other type of distributional implications. But I don't think we have any kind of good reason to think that the poor need more financial education than the rich, or kind of African Americans need more financial education than whites. And I don't think we have good reason to think that. The only point that I kind of made before, and I'll just kind of repeat it, that if we think that the rich don't really need this type of education because they're not making the decisions on their own, they're paying others to make the decisions for them, then on that score, and we do think that education will also have kind of a distributional effect, in addition to just curing the bias.
Thank you so much. So I wanted to go back to this slide that we were talking about, I guess, a question or two ago. And I'm wondering if you think that, going back to what you said about how contract law is sort of limited in its toolbox for what it can do for some of these situations of systemic inequality or injustice, then do you think that's because the doctrine is inherently flawed or limited, or it could be developed in such a way to account for some of these problems? Or do you think we really do have to look to these areas of law outside of contract law? And if that is the case, do you think it's important in a contracts class to spend some time talking about these various other bodies of the law that can sort of counteract some of these problems we're seeing in the doctrine?
Yeah, so that's a good question. My view about the kind of potential of contract law per se to deal with these issues is kind of pessimistic. Okay, so I think that the fixes available within the doctrine are limited in their scope. So I don't think there's a lot that we can do, and this has to do with the kind of the domain of contract law as we perceive it. So contract law is designed to enforce contracts that parties enter into. Okay, so if we have because of discrimination, certain people are just not entering into contracts, contract law doesn't even get triggered. And so I don't think that contract law, this relates to the kind of the first question, there's a lot that contract law can really do. There are fixes that contract law can implement on the margin. Okay? So if we find cases of, say, unconscionable price, the price is too high, or there is other kind of price dimensions that are hidden in kind of the fine print or known to be underestimated, then we can use some doctrines within contract law, like misrepresentation and mistake and unconscionability. We can use them, okay, to nudge the contracts in the right direction. We can use sometimes good faith in order to prevent abusive conduct by the strong as they implement and try to enforce and perform their contract. So we can do these things, and contract law does them. But I don't view them as the first-order corrections to the larger social justice problems that we've been discussing. I view them as kind of second-order, on-the-margin type corrections. And I don't think, and this goes another part of your question, I don't think that this is just a kind of a limitation of contract law as currently applied. I think that if we're just thinking about the comparative advantage, both of different bodies of law and different institutions enforcing these bodies of law, I really think that in order to address these big problems, the best way to do it is not through tinkering with the contract law doctrines, okay, but rather by kind of going to these other bodies of law that I've mentioned. And so this, of course, leads to your final question. And so whether should we talk more about these in the 1L kind of contract law class? And the answer is probably yes. The reason why I'm kind of qualifying is, well, so the first thing I should say is, well, obviously we should talk about them. It's only the question of how much time to dedicate. And this goes into kind of a deeper kind of pedagogical question within the 1L contracts class with the kind of the limits of the 4 hours that we have, is how do we divide the time between just studying the law, and how do we divide the time between business-to-business contracts on the one hand and, say, consumer contracts on the other hand, where a lot of these issues are kind of front and center. Okay? And so, as you know, when I teach 1L contract law, I talk a little bit about consumer contracts, and I talk a little bit about these important issues in that context, including these other bodies of law. But I can't say that this is kind of a major component of the course. It's a relatively minor component of the course. And so that's why you should all come and take my seminar on consumer contracts. Thank you.
I don't want to argue against your claim that a lot of these things are better done through more active governmental processes than by courts. But I think in terms of doctrine, many of the things that you have up there could be restated as contract doctrine. I mean, anti-discrimination law, the right that to quote the first Civil Rights Act, that everybody has the same right to make and enforce contracts as white people do, that could just have been a common law result if the common law had looked for it, as opposed to the common law developing under conditions of slavery. And many of the things that the FTC or the state consumer protection statutes view as deceptive are close enough to common law fraud that you could have extended common law fraud in that direction and accomplished the same result. So I don't think that conceptually these things are in a different universe. I think institutionally they may be in a different universe.
Okay, so that's absolutely right. Professor Rakoff is usually right, so that's not a surprise. But let me just say two things. So there's at least one thing that is clearly, I think, kind of outside of the scope of contract law, even if we want to define it as broadly as you want. So kind of tax and transfer, I'd probably kind of put aside. Now, going to the other areas, yes, we could imagine a contract law that is defined more broadly to incorporate these dimensions. And so I want to say one thing just kind of in line, or completely just agreeing with Professor Rakoff, and then another slightly kind of qualifying. The first thing is, when we're talking about FTC law or UDAPs versus contract law, and fraud and misrepresentation in the current doctrine versus the way the FTC views deception in the consumer protection context, there actually is, a difference in the way these concepts are applied or understood. I think that it's absolutely right that we should bring them closer together. Indeed, we're now working, the ALI is working on the restatement of consumer contracts, where one of the moves, at least the proposed move, this is all just in draft, one of the proposed moves is to replace the general idea of misrepresentation and common law fraud with a broader notion of deception that borrows heavily from the FTC jurisprudence on these issues. And indeed, in many cases that actually come before the courts, you see different types of claims. You'll see a contract law claim right next to a state UDAP claim. Okay, so courts often view these together, and this is just kind of in support of what Professor Rakoff mentioned. The other qualification, and this is, again, this is not arguing against Professor Rakoff, but just accepting his invitation to move from kind of a conceptual distinction to an institutional one. Okay, so I do think that in many cases, the best institutions to implement the change, okay, that we seek are not the courts. And the example that I want to give here is, again, the example of Mrs. Williams. Okay, and so the courts have very blunt tools. They can decide, no, we're not enforcing a cross-collateralization clause. Do the courts have the tools to ask and engage in this inquiry of whether enforcing versus not enforcing is going to make Mrs. Williams better off or worse off, whether it's going to increase interest rates or prices or not, or by how much? Okay? Is it going to reduce the options or the attractive options that Mrs. Williams has, reduce them or increase them? It seems to me that in many of these cases, expert regulators like the CFPB are in a better position to conduct a real study of the market and understand the implications of banning certain provisions or intervening in contracts in particular ways. But that's the only kind of footnote there.
So I actually want to pursue this. It seems to be a theme here, so about the internal capacity of contracts and the external stuff outside, right, doing things outside of contracts. I don't do contracts. I don't, so.
I'm sure you've entered into many.
Right, but, so one thing that does seem to me possible within contract law is to develop ideas of offer and acceptance, so that when Walker Thomas advertises the television at $379, and that's all it says, you develop a law of offer and acceptance, that's an offer that she can, an offer to do it without a cross-collateralization clause. Now, you know, if they say 379 plus cross-collateralization, that's okay. So you could, it seems to me there are ways of, or another way of putting it is actually the law of offer and acceptance is about forcing people to make contracts. Okay, so that's, so there are, I think you probably could develop resources within contract to deal with many of these things. They're just from other sort of silos of doctrine that you'd have to draw on. That's the first one. Second thing is on the, this is sort of a question about both your pedagogy and the organization of the curriculum. So what I would say if I were teaching this course and reached this point, I'd say, yeah, there is this other body of law and there are these agencies and legislatures that can do it. And that's what the course on legislation and regulation is about. So in that course, you can examine what the class, gender, and so on dimensions of getting the FTC to do this kind of investigation. And that, I mean, the pedagogic point is that you can say, yeah, we are going to, you as students are going to study this issue, just happens not to be here. And okay.
All right, so just taking your second point first. So I completely accept the kind of the division of labor and referring students to solutions in other courses. I think that's absolutely right. But I want to emphasize that there is, so the title of this particular talk is Contextualizing Contracts. And I'm talking about contracts as distinct from contract law. Okay, so when we learn about contracts, including in the 1L contracts class, I think it is important to flag the problems, okay, the problems of kind of discrimination and kind of social justice that arise, okay, even if we then say, as you suggest correctly, that many of the solutions are from fields or bodies of law that are outside this class and will be studied in a different context. Okay, so problem versus solution. Going back to your first question about offer and acceptance and other doctrinal tools that we can have in order to kind of solve some of these problems. So again, we can think about reconceptualizations of offer and acceptance. Okay? The way offer and acceptance is currently understood by the courts is that consumers, they get these long fine print contracts, they sign them. You know, we know that they don't read them, and if they read them, they wouldn't understand them. But nonetheless, the courts predominantly believe that that is the offer and the signature is the acceptance and it's your problem. Okay? Now, you know, some people have argued that we should have a radical change in contract law and particularly in offer and acceptance. And maybe that's the, you know, the way to go. But this doesn't strike me as something that common law courts would be able gradually to accomplish. We need kind of a real revolution within contracts in order to accomplish this. Another way to get maybe to kind of a similar place, okay, within the domain of what contract law can, I think, practically accomplish is by testing the relationship between pre-contractual representations and fine print limitations. Okay, so the type of problems that you suggested occur in many cases where you have an advertisement or clear pre-contractual representations, that's how they are defined, okay, trying to get consumers to lure them in. And after they're lured in, through the website or into your shop, okay, into the store, then you sign a contract that basically kind of strips away many of the promises or the value that was initially advertised. Now, that is something that should not be allowed. And I think contract law does have the tools to prevent that. Okay? And so we should definitely not allow businesses to take away or substantially impair and reduce the value that has been promised. Okay? Because we know that consumers do notice and understand and react to the advertisements, okay, or sales pitches made by, you know, the salesperson in the store, but they never read the fine print. Okay, so this type of relationship, doctrinal relationship between these pre-contractual representations and the fine print, I think this is an area where contract law can do a lot.
Okay, so we have to get out. I want to again thank you all and thank Professor Bargill and
Thank you.
By proxy, well, directly Professor Rakoff and by proxy everybody else who's given lectures in this series, and I hope it's been valuable. Thank you.